Recording in progress.
Good afternoon.
Yeah, good afternoon.
Yeah. Thank you for joining. My name is Ahmed Tabbara. I'm a faculty member at PMU College of Law. I'm very happy to welcome this afternoon Professor Samuel Andrews, who is going to present his paper entitled Reconceptualization Alternative Dispute Resolution Ecosystem in the Digital Era, Saudi Arabia's Online Transactional Engagement. Professor Andrews is currently a faculty member at the College of Law at Prince Mohammed bin Fahd University, Al Khobar Dammam, Kingdom of Saudi Arabia. He is a United States Ambassador's Distinguished Scholar and Professor of Intellectual Property Law. He was Professor of Intellectual Property Law at the University of Gondar School of Law, Ethiopia. He is also an adjunct professor of Legal Environment of Business, Criminal Justice, and Cyber Criminology in Albany State University, Georgia, USA. He has lectured in the Doctor of Judicial Science Colloquium, Seminar, and Workshop Program of Suffolk University Law School, Boston, in the USA. Dr. Samuel holds a Doctoral of Juridical Science degrees from Suffolk University Law School, Boston, USA. He also holds an LLM in Intellectual Property Law and Policy from the University of Washington, Seattle, USA. He also holds an LLM in International Law and Jurisprudence, Legal Theory, and an LLB with honors, all from the University of EU, Nigeria. Professor Andrews holds a Barrister at Law diploma from the Nigerian Law School, Lagos. He is a licensed attorney and licensed capital market solicitor. As the Kingdom of Saudi Arabia does not have specific legal regimes that recognize the digital era transactional formations, Professor Andrews will enlighten us on how the Saudi regulator shall conceptualize its curriculum to adapt it to the evolving digital era transactional jurisprudence and promote the updating of the laws of the kingdom to reflect the current realities. It's such an exciting topic, and I'm sure you are all waiting to hear Professor Andrews' ideas and perspective on this matter. Professor Andrews' intervention would be certainly enriched by your question, so please feel free to write your question or comments in the chat box, and Professor Andrews will be more than happy to answer you. Professor Andrews, the venue is for you. Thank you very much.
Thank you, Dr. Ahmed. Yeah, good afternoon, everybody. Welcome. My topic is reconceptualizing the alternative dispute resolution ecosystem in the digital era. So I'm going to use Saudi Arabia as a case study in what I term Saudi Arabia's online transactional engagements. So I'm going to make it short because I really want us to be engaged, to ask questions at the end of it. So I'm going to summarize it. I'm not going to talk too much, and I've given a PowerPoint here which is very explanatory. So based on the theme of this conference, the theme of the conference is Conference on Conflict Prevention and Resolution. So I am looking at the alternative dispute resolution mechanisms. I'm going to focus on, we have so many methods. We have arbitration, we have negotiation, we have mediation, settlement. But I'm going to use, since we don't have much time, arbitration as an example of how we can adapt our jurisprudence in Saudi Arabia to the digital realities. So in the early 1990s, in the commercial arena, the jurisprudence changed in terms of how formation of contracts. So contract traditionally involves face-to-face bargaining, what in Latin traditionally we know as consensus ad idem. That means parties have to bargain until they get to a point of agreement. But when internet and digital systems technology came on board, it became easy for us to, trade online with internet. You can be in hardcover while you transact business with somebody in Geneva or in New York, and it became like a culture until a point in time. For instance, United States courts began to recognize that method. I mean, the jurisprudence now in the commercial area, we have things we call wrap contract, where, for instance, most of us, we use YouTube, we use most of our websites. Before you go into the website, you will see a lot of conditions. They will tell you click. And once you click, you've agreed to the terms of this contract, and that scenario has become an enforceable contract. So it is known as a contract of adhesion because you don't really have much bargaining power. But it's now been recognized by most of the courts in the United States and some parts of Europe. So I want to suggest that we use the same template in our conflict prevention and resolution, especially now that we've just seen what happened during the COVID situation, where the old world was locked down and we could not really do a lot of things physically. So I can't move my screen with the controller. I can't move my screen. Okay, I can move it now. So under the existing jurisprudence, we have the United Nations Convention on Recognition and Enforcement on Foreign Arbitral Awards, what we know as the New York Convention. We also have United Nations Commission on International Trade Law, UNCITRAL. Those are the international treaties that governs alternative dispute resolution, like, for instance, arbitration. But from my observation, these treaties, because it was formulated before the digital age, these treaties does not really address this culture of trading or forming agreement on the internet or online. However, if we look at Article 9 of the New York Convention, it has, for some reason, seen ahead in a little way, because it has mentioned electronic communications. On my slide 6, you see, it mentions electronic communications. So as a lawyer, I would suggest probably, if we have not yet made local laws directly to address, I would suggest we could come under the interpretation that internet, digital contract formations could fall under this section of the treaty. And again, Saudi Arabia law itself, our arbitration law, Article 9, is even more explicit. For some reason, Article 9 even went further than the New York Treaty or the UNCITRAL Treaty. Article 9 of the Saudi arbitration law actually gives us that leeway that we can build on. So it therefore means that as we are right now, if Saudi does not have specific laws that addresses contract formation online, we can fall under this law. But this is not enough. I would suggest down the road that we should also address these issues based on the fact that even the United Nations, they've suggested under what we call the UNCITRAL technical notes. In 2016, the United Nations under the UNCITRAL Treaty has suggested ways of how nations should recognize online dispute resolution. These technical notes are not binding, so that's another disadvantage. They are non-binding, so it's descriptive and it's also advisory. So a country like Saudi Arabia really has to make laws, direct laws, that will recognize this new position. So why am I suggesting that we use a template of commercial contract for instance, political negotiations, political conflict resolution mechanism? I mean, it all boils down to contract. For instance, if nations have disputes, whether it's commercial dispute, trade dispute, or straight political dispute, and the accessibility of digital means could help us resolve those issues quickly without making arrangements to meet somewhere in Geneva or somewhere in the world to talk. So we could use the availability of the digital means by commencing negotiations or commencing mediation. So the immediacy and the accessibility of digital methods will quicken political resolution of tensions. If nations, God forbid we have another pandemic that we could not travel, it will not stop nations from commencing diplomatic avenues of resolving dispute. But you know, the problem of digital transaction is that if there is no law guiding it, it will be difficult for countries to believe in it. So the countries must adhere to the directive of UNCITRAL by making these directives or these technical notes as part of their laws, so that it will be easy. We will have a legal framework where we can commence negotiation, we can commence arbitration, we can commence mediation by sitting down in Riyadh and start the process of exchanging papers and recognizing digital signatures in the political realm, just like it's being recognized now in the commercial realm. And as a matter of fact, Saudi Arabia is very experienced in political conflict resolution. In one of my classes in alternative dispute resolution, we discovered that far back during the days of Prophet Muhammad, peace be upon him, in the Treaty of Undabiyah, we see the classic way how the Prophet doused tension, a political tension that could have snowballed into a serious situation in those days. So Saudi is experienced based on the directions of their faith, their experience in negotiating. So they just have to take this experience onto the digital platforms. And that would not be a problem if we have supporting systems. And where will that support system come from? Negotiating online is a different ballgame. I mean, you have to be experienced and skillful in eye contact. You have to be skillful, even the way your lighting affects your confidence in how to negotiate. So there's a special place where we can train our arbitrators, our online digital transactors, and that place, in my opinion, are the law schools. Because the law schools are specialized agencies who are well equipped to train future negotiators in this special area of practice. So the law schools in Saudi should reevaluate or readapt their ADR curriculum to focus also on adding this new skill set of training, especially experientially, by making their students maybe sit in sessions, online transactions, online negotiations, and train them properly. And because most of the negotiators, most of the ADR experts are actually have law degrees and have law experience. So they won't just train only lawyers, but they can train business people too. But being that it's a law school, they have the infrastructure and they have the capacity and the skill set. I feel this will be a good institutional place where we can train future experts in this area of practice. So, in conclusion, briefly, and we can use the template that we already have, which is commercial online transactions, and we can translate it into the political system, where we can also use, because all conflict resolutions, whether in commerce, whether in politics, sets to achieve one thing: settlement of parties and achievement of the original purpose of whatever party set out to be. So if there is a political conflict, the aim of adopting this method will be to douse tension so that parties will continue their governance without interruption. So that is where I will end now in a nutshell, and I expect us to have serious engagement from what I've done. Thank you. I think there are questions in the question and answer box. Yeah, I agree that that's why I address the issue of expertise. The digital transactional method, it's an added layer. It should come handy when we cannot meet face to face. So it's not necessarily will stand on its own, but where we cannot do, for instance, during the COVID, and we don't expect that world activity should come to a standstill, especially political conflicts that may snowball to war. So yes, although interpersonal relationship is always good in resolving dispute, eyeball, handshakes, but we have also seen in commercial conflicts, because we've practiced it for a while now, that you don't necessarily have to meet. Technology has been created, softwares, and now we are talking now through. This is it's the COVID pandemic that popularized this method of communication. So now the expertise and the training and the online psychology training. There's a class where participants will be trained at least to be able to gauge the feeling through the screen of the other party. Yes, I agree, we might not have the same kind of effect, but we will always achieve our outcomes, because the outcome is to settle conflict, is to resolve conflict. But so if we can settle conflict and resolve conflict even without having physical interpersonal relationship, I think we would have gone a long way to do it. So that's the way I would put it. We can still achieve it because we've already done it in the commercial angle. Are there no students who... Well, if there are no questions, let me just add a little bit before I wrap up, or whilst the students are writing their questions. Now, in developing a curriculum for this method of conflict resolution, I think we should place more attention not just on law, because we have business people, we have strictly political people. We should also construct and develop maybe a course that is multidisciplinary. So, if you're going to be in charge of settling dispute, for instance, between Saudi and maybe for purposes of academic purposes with US, it might not be strictly law. It might be economics, it might be statistics. So the program shouldn't be strictly law, although the law schools are in a better position to host the program itself. Its emphasis should make it interdisciplinary and multifaceted. That's what I will add on that level. Yep. Yeah. Good enough. Saudi already has a basis. Saudi already has. I'm gonna read a little bit because it's not too long. At slide 6. See, Saudi law actually on the arbitration law. Arbitration law of Saudi is forward-looking. So Article 9 of the Saudi arbitration law says that, I'm quoting a section of it, it says that telegraphs or other means of electronic communication So if I would suggest, I would just add other digital recognized contract formations. You get what I'm saying? For instance, I can go further and say clicks, any click, because this is the foundation. This is the law, current law we have in Saudi. So it has given us a direction, other means of electronic telecommunication. So we can build from that other means, and all what we have to do is, define what those other, or expand. I don't know whether you've seen the slide. My slide is not moving. Did I stop? Did I stop sharing? But it's slide 6. If the controller can help me, I can't move it in from this end. But it's on slide 6. My slide, I can't move it anymore from here. It's frozen from my end. But so we have the law already, Article 9, of the arbitration law. So it's there. So there is a law there. But even though it's not specific, so we can just expand that other means of electronic. That's what the law says. Other means of electronic communication is recognized for arbitration purposes. Email, telegraph, So all what you need to do, maybe specifically you talk about the internet and the other softwares, online systems, and even offline. You can even include metaverse, the new technologies, because the new technology does not only deal online, it deals offline. Yep. All right. Anybody who wants you can send me an email. I can send you the slide. Anybody who wants the PowerPoint, I'm available to distribute it.